I'm Gerard McDermott from Outer Temple Chambers, but for today, more importantly, Gerard McDermott from Manchester, and as some of you know, Stalybridge. I'm delighted to welcome you on behalf of Outer Temple to this seminar, and thank you to all our staff for setting this up, to Vicky and Paul, and of course our Chief Executive, Rebecca Priestley, who's with us today. I'm going to chair the first half of the afternoon, and then Ian Denham's going to close it at the end of the day and the last session. Can I thank as well, not just the speakers from Outer Temple, but particularly the speakers who have come as guest speakers, if I can put it that way: Thomas Ricard, Mark Harvey, Jennifer Lund, and Colin Murphy. Mark Harvey tweets a little bit. And so I know from this morning when I said I was looking forward to seeing him, he said, "Oh, well, thank goodness there'll be someone else with grey hair there." We will have no comparative assessments of that, but it's true. But thank you all to add to this. And welcome to all our people online as well. I hope you'll find it enjoyable. Our first session is going to be on litigating road traffic accidents abroad after Brexit. Well, what a voyage of discovery that many of us could have predicted. And of course, you will all have clients who find it's either all so much more difficult or almost impenetrable now. And I'm delighted to welcome Colin Murphy from Leigh and Carin from Outer Temple to talk about this. So here's my confession. I walk up to Colin and say, "I don't think we met before." He said, "Well, actually, probably 3 or 4 times." Okay. And he explained his history. He said, "But Gerard, you've been around so long in travel law, it's understandable you forget." He didn't mention the age, but I'm sure he meant that as well. I am also delighted that Colin is from East Manchester and knows exactly where in Stalybridge we are and exactly where in Ashton-under-Lyne, which is even more obscure than Stalybridge, I live. So welcome, Colin, and thank you. He obviously has built a stellar career at Leigh and is very clearly a very well-regarded lawyer in this field. And Carin Hunt is one of our junior tenants at Outer Temple. She undertakes a lot of travel law. She also undertakes personal injury and clinical negligence and employment, and also has got a very interesting development in the sense of representing people at various international tribunals in terms of the World Bank and so on, and disciplinary proceedings. We're lucky to have such really great talent in Outer Temple. When I say particularly at the bottom end, of course, I've got to be careful that I don't alienate the top end. But there we are. I'm not sure you need any more introduction than me, Colin and Carin.
Thank you, Gerard. I'm just going to do a quick introduction and then Colin's going to launch in to the talk. I told Colin not to worry about what Gerard said because for about 2 years of my tenancy, Gerard kept introducing himself to me. All friends now. Really nice to see everyone here and have you here. Obviously, for the day that's in it, I will be presenting my entire talk through Irish. Perhaps not, but maybe later in the bar if you catch me there. We're already very late for the pub. So thank you for coming. Thank you for coming in person, to those of you who are here, and those of you who are at home watching. And as Gerard said, particularly thank you so much to Colin for joining me today to speak on it. We're going to talk about handling European RTA claims after the end of the transition period, and of course after Brownlee as well. The aim is really sort of to give you a practical refresh of the key points that you need to keep in mind, which some of you will be very familiar with, but hopefully will be helpful to others, and also some relevant updates. And Colin's going to look really at some helpful practicalities on service and enforcement as well, which I think is the bit that's really giving a lot of us pause at the moment. In terms of what we're going to cover, I did not bring the clicker up here with me, which is my first failing. I'm just going to, there we go. Haven't learned anything from Chris Whitty. This is what we're going to be going through. We're going to give you a very quick background, which we all know, I'm very familiar with. Brexit means Brexit. We're going to look at the pre-Brexit position. That's going to be Colin, and he'll take you through those points. And then I'm going to talk about the post-Brexit position, where we are, what we might be looking at going forward, and also some practical considerations. And that's back with Colin. So in terms of that background, we all know it very well by now. We've left. We didn't get Lugano, so we're out in sort of the common law wilderness where all the other non-European law claims were beforehand, and that's what we need to face going forward. So before we look at going forward, Colin's going to set out where we were beforehand. So up you come, here is your paper.
So yeah, I'm just going to cover off where we were before Brexit, and by Brexit, obviously, cases issued before the 31st of December 2020. And I expect most of you will still be familiar with the old rules because, you know, whilst 2020 seems like some time ago now, especially with what's gone on, the cases appear to be very much so live at the moment and working their way through the court process. And if you have if you've been allocated to Maidstone County Court, you might still be waiting for a CMC date. So, applicable law, the Rome 2 regulations, this was what governed the law which applied in tortious actions, and for the purposes of RTA would have been the main reference point. The default position was it's the law of the country where the tort happened. And there were two exceptions. Where the claimant and the defendant had their common habitual domicile, it would be the law of that jurisdiction. And where the tort was manifestly more closely connected with a different jurisdiction. And obviously case law evolved regarding that. And just as a throw-all, obviously in claims against the MIB, we had the decision of Moreno versus MIB, which clarified that in assessing liability of the MIB, it would be by reference to the law of the torts as well. Jurisdiction, as between the EU 28 and the EFTA states, was determined by the Brussels recast regulations and or the Lugano Convention. For everything else, so for cases concerning jurisdictions other than those within Europe, you have the common law test, and we will go on to discuss that. In respect of both Brussels 1 and the Lugano Convention, they provided mandatory rules and jurisdiction. And importantly, again, there was no forum convenience test. So I guess from the perspective of a lawyer dealing with these cases, it was quite easy to determine whether you would get jurisdiction. The rules were quite clear. The general position, the defendant should be sued in their own jurisdiction. In matters relating to tort, the claim could be brought where the damage was sustained. And in that context, it was direct damage. And it also provided provision for actions against insurers and for a claimant to be able to pursue a claim against an insurer within their own jurisdiction, provided there was a direct right of action under the law of the torts or under the contract. And again, there was clarity in the rules, and that made our job significantly easier. But looking at it from a different perspective, the rules in some respects were quite rigid. And because of that, it did create difficulties for people practicing in the areas, especially the rules on this pendants and, kind of the commonly known Italian torpedo, where spoil proceedings were frequently used to frustrate or even prevent progress of a claim within the jurisdiction. Service was great. Pretty. I mean, it was just so nice. We had the service regulations, but more importantly, we had the UK handling agents. And because of Spedition, we could serve on the UK handling agents in RTA cases. So the whole concept of a foreign insurer seemed a little less frightful when you knew you could go down the road and kind of serve the local UK handling agent. obviously we'll go on to see what the position is, but it won't be a surprise that it's not as so happy. It's not a greener place. Technology's letting me down. My clicker's broken. And that concludes the presentation. This wouldn't have happened pre-Brexit. Oh, there we go. Right. Yes, we're good. And enforcement, again, this wasn't something that we really needed to be too concerned with. Both Brussels recast and Lugano provided for a direct recognition of the English judgment. So if you were successful in your claim, you got your judgment from the Court of England and Wales, that judgment would be recognised in the foreign jurisdiction where you were looking to enforce. Now, in practice, what this meant was a relatively straightforward application to the court for a European enforcement order. You would send that European enforcement order to your local lawyer, and 2 to 3 months, maybe a bit longer, you received a nice check. It was effective. And again, this is kind of a huge benefit of the pre-Brexit position was the Motor Insurance Bureau. The Motor Insurance Bureau obviously acts as a compensation body for UK residents who were injured in road traffic accidents in the EEA. And they also served as they would reimburse foreign counterparts. For example, if someone traveling from France had an accident in England, if they submitted a claim to the Foreign Guarantee Fund, they in turn will seek recoupment from the MIB. Seamless system. And in practice, what happened was that at the start of the case, even if you had or suspected details of the third-party insurer, you would probably still put a request into the Motor Insurance Bureau just to confirm those details. The effect of that request under Section 12 and Section 13 of the Motor Vehicles Compulsory Insurance, I'm not even going to carry on, but you get the gist, was there's 2 months to identify the relevant insurance body. And if they fail to identify the insurance body within that 2 months, an entitlement to make a claim against the MIB arose. So there was quite good protection there for a victim of an RTA in a foreign EU country. So I think we're going to go on to what's changed.
Thank you. Yes, so what has changed? Well, this is probably the more familiar bit to you, but Colin will get up and talk to you about how service has changed for the worse, we might say, later on. But first of all, well, applicable law, thankfully, we have that remaining the same. Of course, we do have the caveat that the English courts now can interpret retained European legislation differently should they wish to, but so far nothing significant on that front. So then jurisdiction, which has changed. We had some hope that we would get to accede to Lugano and to have those rules, which very much mirror Brussels recast and would have kind of allowed things to continue on, but it doesn't look, it didn't happen for sort of reasons that were given. We're not in the internal market and so on. Some felt it was a slightly politicised decision from the Commission, and we'll see if we get anywhere with that in the future. But for now, no Lugano, back to common law. And we do have some additions in the form of the new consumer and employee provisions for jurisdiction in the Civil Jurisdiction and Judgments Act, and that's just something to be aware of in case your road traffic accident happens to either be you've got a connected consumer contract claim or you've got an employee driving abroad, and you might be able to use that option as opposed to going through the rigorous common law route. So just something to keep on the radar, but in the main, for road traffic accidents abroad, if you're on holiday, if you're visiting family and so on, what are we looking at? Well, we're looking at the common law test in part 6 of the CPR and the accompanying practice direction. And of course, timing wise, we've said it's the end of exit day, as long as you've got your claim instituted before the end of exit day. And we know that that means just served and served properly, which hopefully we've all done, but we are certainly seeing a few debates coming up about that with some cases. So in terms of getting that permission under the common law test, either it's now all about service, and it's all about, well, can you serve one if we've got multiple defendants, can you serve them in England because they're located there, which is easier, or if not, you need to get permission from the court, and it really front ends and front loads the litigation process, because you've got to do all of that sort of at the very beginning. How do we get permission? There's 3 hurdles. We've got to get through a gateway. We've got to show reasonable prospect of success. That's sometimes called the serious issue to be tried or the merits test. And you've also got to establish that England is the appropriate forum for the claim. That's the bit where really the discretion is coming in. That's the bit where we're losing certainty, and where everything's going to turn on the facts of the case. And it's much harder to tell a client or be confident about what the court's decision will be. So that's where we've kind of had the real shift and change, and of course as well less current case law on it now, because of the way that European claims were being litigated. So the international environment has changed, and factors that are relevant to forum might have changed as well. And those tests are satisfied at the time proceedings were commenced. The burden of proof is on the claimant. And the claimant also needs to do some procedural things like identify the claimant's address or say where they might be found if they don't know the technical address. And of course, the thing to remember that these applications are usually made without notice. So you do have that duty of full and frank disclosure. You are at your own risk if you do not comply with that duty, because it could really come back to haunt you. So it is important to point out to the court factors that weigh against what you are arguing, as painful as that may be. So the first test, getting through a gateway, they're in practice direction 6b, paragraph 3.1. It's what's called the good arguable case. The old case law got kind of, well, I found it terribly impenetrable on this. We had lots of glosses, lots of chat about, well, what is the test, what does it mean? Thankfully, Sarah Crowther came along and clarified everything for us. Well, I suppose the Supreme Court clarified it, but much of muchness. And so we got a nice sort of setting of like, what does this actually mean? How much do you have to prove to get through a gateway? And the question is really, it really takes into account the fact that, again, we're at the very early stage of proceedings. This is the beginning, not the end. So what's known and what's in issue is all sort of at that early stage. So what the claimant has to do is provide a plausible evidential basis for the gateway. And if you have issues or disputes about some of those, the basis for the gateway, the court has to take a view on the material available. If the court says, looking at this, I can reliably say, yes, the accident happened here, or yes, this is the applicable law, whatever, that's fine. But if the court recognises that it's limited in what it's able to rely on as a material factor for the gateway, then it just has to have a plausible evidential basis. So that does provide a bit of a cushion for the fact that you are at this early stage, that there may still be matters that haven't been decided, particularly as we know it can all take a little bit longer when we're dealing with our foreign experts and bodies abroad. So that's now what we have as what actually is the kind of burden on us to get through a gateway. What gateway do we want to get through? If we're looking at road traffic accidents, again, it's the tort gateway that's going to be the most obvious one for us. And again, Sarah has come to the aid of claimants everywhere. Okay. I hope that. Bye, everyone. Should I come in person? So we have the definition of damage here, which again you will be familiar with, so I won't labour it too much. But essentially, we're not constrained by where the cause of action occurred, that as long as you've got some consequential damage suffered in England, then you can get through this gateway. One question that does arise is sort of how significant does the damage need to be? Obviously, for Lady Brownie, it was very significant damage. Is there sort of a de minimis standard there for the amount of loss of earnings or the amount of pain and suffering? Reading Brownlee, that there isn't. Indeed, Lord Legate, who was the only person to disagree with Sarah on this, is concerned that the meaning of damage could be so low that cases are just kind of going to come in through this gateway. But everyone else recognised that really forum is the fetter to that happening. So you're not going to have a huge damage hurdle, other than also obviously the sort of economy of the case and things to think about that way. But it doesn't look like that's going to be an issue. So just because the accident happened abroad doesn't mean you don't get through that gateway. Then just looking, oh dear, wow. Oh, there we go. Oh. Oh, she's amazing. Everyone should have a Vicky bun. So yes, just quickly, if you're not doing the tort gateway, just to be aware of, we all know the anchor defendant gateway. Just a point to make that if someone's voluntarily said, oh yes, actually it suits me to be in England, then they're not a great anchor defendant following this case. So be aware of that. You've also got, if you've got someone domiciled here, closely connected facts, and the contract gateways, as you will have a concurrent claim and contract, but obviously in terms of recovery of damages, that's not going to get you where you need to be. And then there are the new Civil Jurisdiction and Judgments Act provisions as well, which you can be aware of, particularly when looking at employees. That might be a helpful way of avoiding all of this fun. So then we get through our gateway and we've got the merits test. Oh, sorry, Vicky, I'm going to now more dramatically click so that we can make that look more swishy. Great term there. Yeah, so merits, again, you've got to prove a reasonable prospects of success. What does that actually mean? Well, it's basically the test for resisting summary judgment that's been established for ETB Capital and lots of other cases. So that's at least clear. The other kind of phrase used is a real as opposed to fanciful prospect of success. And the sort of rationale behind this is that you shouldn't be putting a foreign litigant through the inconvenience and expense of having a claim litigated in England and Wales if that claim is liable to be summarily dismissed. That just doesn't seem like a good public policy point. And so that's really the operation of this threshold and why it's generally quite a low threshold. It's also one that has to be approached proportionately because, again, we are at the very beginnings of the case. So there are certain, the court is really taking a preliminary view. It's not engaging in a mini trial. Same issue with summary judgment, really. One question that arises is, do you need to provide evidence of the foreign law in order to prove that you've got reasonable prospects of success if you've got a foreign applicable law? No, technically you do not, but that doesn't mean it might not be useful to you to do so, particularly where you're kind of going to need to know that anyway to advise on prospects. You might want to amend pleadings and so on and so forth, but no, technically you do not have to do it. There's a long academic ramble about this in Brownlee, thanks to Lord Legate on Sarah's side for once. She got him in the end, and he said that yes, there is a rule of evidence about foreign law, which is that in the absence of material evidence, otherwise the court can infer that the foreign law is materially similar to the English law. And obviously that's a flag for defendants there, that if you want to put in some evidence that it's different, you can do so and rebut that presumption. And that sort of fights against the points that defendants were making in that case, which is it's unfair and it sort of unfairly puts the burden on the defendant, but that is where the burden lies. And then just one final point is that for defendants, again, the idea that the same with really when you're dealing with summary judgment, the more you have to get into the facts of the case and disputed issues, the less likely the court's going to be convinced that there isn't a case there. So what you're kind of tactically trying to do is find the one killer point that says, no, look, this is rubbish, because the more you get, well, I wouldn't say it quite like that in court, I promise, but you know, the more you have to get into the facts and the details, the more the court's going to think, this is something that really requires a case. Finally, forum. I'm not going to spend too long on this because luckily Will Young's going to take us through that in a lot of detail, and particularly looking forward as well. But I suppose the main thing, which again, hopefully we all know, is it's not convenience, it's interests of the parties in the end of justice. It's not about what suits you, it's what about suits justice, whatever that might mean. Spiliad obviously gave us some nice commentary, the OG of forum, in sort of what this might mean, but broadly speaking, we're looking at a two-stage test. The key bit of the step test is sort of the connecting factors point. So we've got sort of some examples there of what might be a connecting factor to make England the more appropriate forum. There are factors of convenience in there, of course, but there are also points about the applicable law, where the accident occurred. Because we're talking about road traffic accidents, it's important that the place where the accident occurred is really no more than a starting point. It's not presumptive. It sort of gives you a starting place, but it doesn't mean that that's where forum lies. The court will really look at the facts of the case more than anything. And certainly in the case of Cleef and Slater, which Will is going to talk about, I think that really emphasises how detailed and granular the approach to looking at the facts of the case are when considering where is the appropriate forum. So, for example, if your case is quantum only, that's going to have a huge shift in terms of how relevant is the place where the accident occurred. As well in there, you know, the court looked at actually the specific location of the court in France where the case would be heard if it were to be heard there, and then looked at the distance and convenience of the parties getting there versus London. So, you know, really going into detail, and it's a really helpful thing that each time you get one of these cases before you and you're looking, what are they going to say on forum? The more detail you look at, the more you might just find that little key point that helps you. Can your foreign law expert also give evidence in English? That's, you know, going to be a helpful factor. All those different little points. So the key takeaway is really just to look very specifically at those facts. And then the second stage, the need to do justice. You've got to have a real risk that substantial justice won't be done elsewhere. So for European countries, not generally a huge issue unless you've got sort of delay and things like that you could potentially point to, and won't name them, but you know who you are. And then finally, in terms of getting jurisdiction, we also want to talk about contesting jurisdiction from the defendant perspective. Obviously, the point we all know is don't do anything that would be seen to be accepting the jurisdiction whilst you're busy contesting it. Don't serve a defence, don't ask for more time, don't do anything like that. And you've got to put in your application once you get your claim served, and you can seek more time, because I think it's technically 14 days, but that's not very long if you obviously need to get things moving in terms of foreign law evidence. If you're going to, for example, rebut some points there in terms of the prospect test. So that's what you need to do. One thing to keep in mind is costs. If a claimant solicitor has truly brought a claim that should not have been brought in the jurisdiction of England and Wales, you could look for a wasted costs order, and because you'd be bringing it against them directly, the Quox provisions wouldn't apply to protect them. So if you're kind of getting one of those rogue solicitors that decides they're going to do cross-border cases and suddenly you're thinking that really isn't right, you know, it is certainly an option on the table, or at least one to raise. And that is it from me, and now Colin's going to do the hard bit. Sorry.
So you've jumped through the hurdles, you have permission to serve outside the jurisdiction. How do you go about it? So, I mean, the main point really is the foreign insurer is no longer obliged to appoint a UK handling agent. And therefore, the avenue for service that was more familiar to us is seemingly no longer available. You know, in preparing this talk, I did kind of consider what the incentive is to a foreign insurer not to appoint a claims handler. And, you know, in balancing that kind of exercise, other than, you know, just to be obstructive, which we know foreign insurers are not necessarily inclined to be, the appointment of a claims handler in the UK seems to strike a number of benefits. You know, it's a familiar approach. You know, just because we have lost Brussels recast and the Ghana, you know, they're still operating a similar system in different jurisdictions. So the appointment of UK handling agent is familiar. It might be commercially attractive. You know, the question of costs of dealing with a claim in-house as opposed to externally, you know, is going to probably be a factor moving forward. UK handling agents have experience of dealing with UK civil procedure, and they have familiarity with dealing with us. You know, they know our natures, they know what will float, what won't. And obviously, by appointing the UK handling agent, they potentially get the benefit of their connections. So you know, typically speaking, from my defendant days, the UK handling agents have quite good agreements with defendant solicitors, defendant lawyers, which foreign insurers could take the benefit of, and rather than negotiating an ad hoc deal. But you know, all this is speculation as to what they intend to do in terms of the future of kind of UK claims handlers. But I think, you know, there is hope. You know, from my side of things, there seems a kind of a rationale in terms of appointing a UK handling agent, and certainly it seems by having a UK handling agent accept service or a defendant solicitor accept service, there's going to be significant cost savings. But you know, we'll see how that picture lies as we move forward. Failing that, then the alternative is to serve outside the jurisdiction, and if you're doing so, you're going to be serving either under the Hague Convention or by any other method permitted by the law of the country in which you're serving. So how do you do that? I would probably suggest that the slides are somewhat out of sync, because I think service is something that you certainly should be thinking about at the point of issue, and certainly at the point when you're applying to for permission to serve out. A quick email to the foreign process section will give you their kind of latest update on what methods of service are acceptable in the country where you're looking to serve. Typically speaking, you drop them an email, they can come back in a week, 2 weeks with a nice summary of what you have to do. I always cross-reference that with the Hague Convention website. The Hague Convention website is periodically updated depending on preferences shown by members, and therefore, just because you have the information from the foreign process section doesn't absolve you from checking the accuracy of that against the Hague Convention. I've got the website there. If you're considering doing it by a method that is acceptable in the country where you're looking to serve, then you're going to need a local lawyer. And from experience, I would probably advise a degree of caution when adopting this approach. You need to have confidence in your lawyer and confidence that they understand what it is you're looking to achieve. And the reason I say that, if, you know, on occasion I've encountered situations whereby service is determined by a classification of the document. Depending on the classification of the document, it depends on what method of service is acceptable. And quite frankly, proceedings issued in a foreign jurisdiction doesn't sit comfortably with that classification. So therefore, I think you need open and frank discussions. If there's any uncertainty as to whether you can serve by kind of a local method, then typically I would adopt belt and braces approach to service, because if you fall down on this hurdle, you know, your claim's not going further. So look to serve under the Hague, and if possible, look to serve via a local lawyer using a method that's acceptable in that country. You have 6 months to serve outside the jurisdiction. That is not much time, and we are all very busy. So I think you need to give due consideration to whether you need an extension of time and whether it is reasonable for you to apply for an extension of time. And that's why I suggest that this is something you should be factoring in at the very start of proceedings being issued, or at the very least when you're looking to apply to serve outside the jurisdiction. You need an idea of what you need to do to serve and how long it's roughly going to take you to serve. And again, the foreign process section is quite good at giving an indication if you are serving via their methods. Equally, do not underestimate how long it takes you to prepare and finalise your court documents, your particulars, your medicals, and get them potentially translated if required to do so. So let's have a look at applying to extend time for service, and just as an additional consideration, applying for alternative service or an alternative method of service. So in summary, the court can give you an extension of time for service, and in order to do that, you need to be able to demonstrate you've taken all reasonable steps to serve and to serve within the 6 months. Now, you also have to apply promptly. So, for example, if at the point of issue, or kind of 2-3 weeks after you've issued, you email the foreign process section and they tell you it's going to take 9, 10, 11 months, or incidentally, if you're looking to serve in Taiwan, 2 years, then you're going to need to be ready to make an application. It's not going to be sufficient just to sit back and hope that defendant solicitors are appointed to accept service. To apply to extend time for service, you'll need an application. The application will need to be supported by a witness statement. The application can be made without notice, and because of that, as we all probably know from the case of Gunn, you need full and frank disclosure, and that can be somewhat problematic if you just sat back. And therefore, I would suggest there's probably an incentive there to, if you're applying to serve outside the jurisdiction, consider whether at that time you also want to apply for an extension of time for service, because if you're making your application after you've got permission to serve out, then I think there's going to be quite a high degree of scrutiny of what you've done and when you became aware of the timescales. The application really should address the steps you've taken to serve, why it's not been possible to serve, the date you became aware that an extension of time for service would be needed, and exhibit any relevant correspondence. And typically what you would exhibit is the correspondence from the FPS or the local lawyer, giving an indication of the timescales. When you're making your application and when you're preparing your witness statement specifically, you need to have take into consideration the following principles: soda stream limited versus Coates, and further clarification from other cases. But what is the good reason that you've been unable to serve? The fact that you've just not been efficient enough isn't likely to float. The defendant is under no obligation to facilitate service, and I think the hope is always there. If you manage to get a defendant on board to accept service, you avoid the need to translate proceedings, you avoid the need to kind of go through the rigors of an application to serve out. But I think in terms of protecting your position, assume that no solicitors will be appointed until such time as they come forward. As long as you're giving them notice of your intentions to issue to serve, and they're still not coming forward, I think it's an argument for costs at a later point if they later step forward and say, actually, yeah, we'll accept service. The court will always have regard to the overriding objective, and in doing so, we'll try to ensure that parties are on an equal footing and the case is dealt with fairly. And I think this ties on quite nicely with limitation, because the process of gathering your evidence, issuing proceedings, applying to serve outside the jurisdiction, applying to and actually serving can take quite a bit of time. And I think for those who, where there's the opportunity to extend time, to extend limitation, I would probably strongly recommend you do so until such time as you have served and there is a defendant engaged in proceedings. Where there isn't an opportunity to extend limitation, I think it's going to have to be a factor of when you decide ultimately to push the button and to issue in order to try and secure jurisdiction. But I think limitation is always going to be a point the defendant will put forward in any challenge to jurisdiction, on the basis that if limitation is expired before you have served, it is certainly going to be difficult, I think, for a judge's assessment in terms of the overriding objective. Perfect. Alternative service. The court can authorize service by an alternative method or service at an alternative place if there's good reason to do so. I've given some examples of kind of, in particular, the on the beach limited versus meeting point you travel tourism is a very good breakdown of the position. I think in terms of, in that case, meeting point you travel had agents in London, but for all intents and purposes, their marketing and pretty much all their online material would suggest that meeting point you travel had offices in London. In the jurisdictional challenge, meeting point you travel came forward with a number of documents that were not available to On the Beach because they were commercially sensitive, and On the Beach sought permission or sought approval of the court for the service that they effected on at the London agent address, and in that case, the court kind of accepted that there was. Well, I don't even think that the court could readily identify whether it was or wasn't an office of meeting point you travel, and so approved alternative service. And yeah, so for less likely to be relevant in RTA claims, but just kind of service generally, is it appropriate to seek alternative service? Applying to extend time for service in practice. Well, this is a recent decision, and it effectively involved effectively a group action claim arising from misuse of data under GDPR, and the history is on the screen. But in a nutshell, it should have been obvious to the claimant solicitors that they needed to serve. Well, there was 6 defendants, only one of which was in England and Wales, and therefore, in the absence of defendant solicitors' acceptance service, it should have been obvious to the claimant too that they would have been required to serve outside the jurisdiction. There is quite a lengthy history, but in essence, it was quite some time after proceedings were issued. There was a short stay pending a relevant judgment, and when that judgment came out, the stay was lifted and there was approximately 3 months left to serve the claim form. It was only very late in the day that claimant solicitors contacted the foreign process section to inquire as to how long it would take to serve the defendants, one of which was in China. And the FPS came back and said it'll take at least a year. And despite that, they still didn't issue an application until about a month later. So they got the response from the FPS saying you'll need a year. This is as they were approaching a service deadline, which was effectively 2 months away. So they should have known at the point when the FPS replied that, at the very latest, they should have known it when the FPS replied that they needed an extension of time, but still they delayed the application. Their application dealt with permission to serve outside the jurisdiction. a straightforward extension of time for service and permission to serve the claim form by an alternative means. Now, on the first limb, the court accepted that, you know, it satisfied the gateway and that permission to serve out should be given. On the second, in terms of the extension of time, the application was refused, and the judge was quite critical, probably quite rightly so, given the history of the case. But it wasn't a straightforward application. The chronology put forward by the claimant was apt to mislead. The defendant solicitors have been consistent throughout the correspondence with the claimant solicitors that they were not going to be authorised to accept service of proceedings. And kind of, I think the judge accepted the reality was that the extension of time came from the failure of the claimant to take the necessary steps. And in that case, extension was refused. And unsurprisingly, the permission to serve the claim form by alternative means was also refused. Enforcement. Hopefully you'll receive copies of the slides, I expect you will, because I'm not expecting you to read it, but the position on enforcement is quite, it's difficult. It's not impossible. We lose the benefit of the automatic recognition of a judgment from the English court. So what we have to effectively do is through our local lawyers, and I've identified those that have helped me in compiling these tables, the considerations that will be taken into account when determining whether a judgment of the Court of England and Wales should be recognised, and then whether it should be enforced. On the whole, the feedback I got was there isn't going to be an assessment of the merits of the decision of the English court, which is good, but they're not going to reopen that chapter. But from the perspective of your client and arguably the kind of the business interests of a law firm, having a judgment recognised and then enforced is going to probably involve considerable delay. 6 to 12 months in France, Spain 9 to 24 months if the defendant objects, and is going to incur additional costs. Those costs aren't necessarily going to be recoverable as part of the enforcement process, in which case I think it's a commercial decision for the law firm to what extent those costs are taken on the chin, if they're costs and if the judgment is for costs and damages, or to what extent the client might become responsible for the costs, or indeed what can be worked out with the local lawyer. But certainly the picture has changed somewhat. It's more difficult, it's going to be more costly, and it's going to take more time. And well, what's changed in terms of claims against the MIB? Well, yes, there's quite significant changes there. Unfortunately, people who are domiciled in England and Wales who have accidents in Europe are not going to have the protections that they had pre-Brexit in terms of uninsured or untraced drivers. They will have to submit a claim to the Foreign Guarantee Fund, yes, it's certainly not an ideal situation. On the upside, you can still submit a request for information from the MIB. In theory, they can provide you with the foreign insurer's details if you're able to provide a registration number. It seems to me the 2 months that they had pre-Brexit is now no longer in place. So faced with a kind of COVID, working from home, demand, what they're getting back from the Foreign Guarantee Fund, I think it's a watch and wait. So ideally what you need to establish from a very early stage from your clients is, do they have potential details of the foreign insurer, and making contact as soon as possible to make sure that there is cover in place, because waiting for the MIB, you might be waiting some time. And finishing off with some, from practical considerations, oddly enough, when I was looking to do the talk and looking to the factors that I think might be relevant, it's quite difficult to say, because we've had Brexit, we then had COVID, so no one was travelling, and then we had, or we awaited the decision of Brownlee, so we didn't really take many cases involving RTAs. So this is a bit of trial and error at the minute, but these are just some of my musings as to what I think we need to be doing, or what we need to be considering. I think in terms of when we're approached by a client, the first stage is what's going to be in the client's best interest, and we know if the accident has happened in France or Spain or wherever, that there is a potentially valid claim that they can commence in that jurisdiction. So what are we going to say to the client that approaches us, that England, or that they should pursue the claim in England as opposed to the foreign jurisdiction? Cost implications are one. Kind of historically, the English cost rules have been quite favourable to claimants, and it's not necessarily mirrored in other European countries. So therefore, the fact that there is no cost exposure under a no-win, no-fee agreement for the client could potentially be a relevant factor to that. I think it needs to be clear to them what the position is on enforcement, because it is going to potentially delay the claim, hopefully not too much with motor insurers, but in claims generally. If you have a difficult insurer and you are having to enforce, it is going to add on quite a significant amount of time, and the client needs to be aware of that. I think the advantages of proceedings in England over foreign jurisdiction, what I mean by that is historically the English courts have been, well, I think they've become accustomed to dealing with cases involving foreign jurisdiction, foreign law. And in terms of the decisions they make are oddly at times more favourable to a claimant when applying the strict letter of the law. And from my experience, I'll always remember a case I took to trial, which was a very straightforward RTA involving Spanish law, and there was effectively a soft tissue injury lasting 15 months, and there was our Spanish law expert explaining the Baremo and the data consolidation, and the defendant's Spanish law expert, and the argument advanced by the defendant in that case was oddly that in Spain they would never get this prognosis, they would never get this time period, and therefore they would never get this award of compensation. But thankfully in my case, on the strict interpretation of the Baremo alongside the English medical evidence, the award was justified. But if in the foreign jurisdiction there is a kind of a standard, a reluctance, a certain level or a certain perception of how awards should be made or what those awards should be. Again, as I say, historically, the English court have been quite accustomed to kind of deviating from that if there's valid reason to do so. ATE cover, again, this is probably behind the scenes, but in those finely balanced cases where you are looking to establish jurisdiction, those riskier cases where it might be a short-term injury or a short-term loss within the jurisdiction or fewer connections to England. I think it will depend largely on what the foreign insurer's appetite for risk is, and I think that probably involves, thankfully, discussions at probably higher levels than I'm currently exposed to, but it is probably going to be a relevant factor moving forward. In the event of BTE, I think the issue there is, is the BTE cover sufficient to deal with any jurisdictional challenge? Will they need a top up? Or should it be used to deal with any jurisdictional challenge? If the BTE cover provides for funding for litigation in a different jurisdiction, is your client in a better position to have a policy of ATE taken out to deal with any jurisdictional argument here, and have the BTE as a fallback position should they need to litigate in the foreign jurisdiction. And again, when do you issue? And again, it's finely balanced. As I explained before, it all takes time to prepare your case to issue, to get it ready to serve out, to get permission to serve out, and to serve out. You have to have one eye on limitation, but also you need to build the connections to the jurisdiction. So you need to give yourself sufficient time to build your connections to the jurisdiction and build your case as to why the connections to England are sufficiently strong to get over the foreign convenience test. Whilst keeping in mind, actually, you don't want to prejudice your client should you lose the jurisdictional challenge and they're having to commence an action in a different jurisdiction with limitation pending.